Welcome, everybody. Welcome. We are here for sentencing. Let me pull it up right now because I think it just started. Let's see if I have the right thing here. I think I do. I think I don't. Hold on. Okay. Now I'm broadcasting to myself. Okay, hold on. Here we go. I think I got it figured out. First, I need to take care of this. Goodbye. Here I am. Okay, that should take care of the echo. Let me pull up court feed. Sentencing. And it looks like right now we have talking heads going. Oh, somebody's in court. Is this, that's the closing argument. I'll go ahead and hide that now that it's ready. Let's see. Welcome, welcome. So it looks like we're here on time. Hey, I want to hide that. Hold on. There we go. All right, just wanted to make sure I had it ready. Welcome, everybody. Welcome, welcome. I wasn't sure who was going to stream today. I thought Joe, Good Logic, might be streaming, but it appears not, so I decided to hop on. So this is, of course, the Alex Murdaugh trial. He was found guilty yesterday of murdering his wife and his son in what I would consider an absolute travesty of justice. This is a bad trial, and I say that not with anger, but with disappointment. Like a father with a troublesome kid. I don't know of any legal system in the world that does a better job of approximating something like justice than our American system, but it's imperfect. It's imperfect. And this trial was a terrible example of how imperfect that system can be, how corrupt it can be. And that's got nothing to do with whether or not Alex Murdaugh is a nice guy or not. I don't think he is a nice guy. All right. Looks like we're here. Court's in session. Let me pull that up.
Good morning. Parties ready to proceed?
State's ready, Your Honor. Bench is ready, Your Honor.
All right, from the state, Mr. Waters.
Thank you, Your Honor.
Maximum.
We're obviously here in the sentencing for the state versus Richard Alexander Murdaugh. Your Honor, I have prepared the sentencing sheets signed up. If I can hand those up to the clerk.
We had a corrupt prosecution, corrupt law enforcement, corrupt judge.
Your Honor, very quickly, the defendant has no prior record, and the state has no victim impact people who want to speak at this time. But I will address the court briefly. And I don't need, Your Honor, to repeat the evidence that Your Honor just heard for the past 6 weeks, but it is overwhelming. And it shows this man to be a cunning manipulator, a man who placed himself above all others, including his family. A man who violated the trust of so many, including his friends, his family, his partners, his profession, but most of all, Maggie and Paul. This is a very complicated situation, and I want to offer my condolences to the family that has suffered here. We have tried very hard to be respectful and sensitive regardless of what position any person took, because this family has suffered, and they've had to suffer in the public eye, and I want to offer my condolences to this family. I want to offer it for Maggie and Paul and Mr. Randolph too, who I had the pleasure of working with on one occasion. But the reality remains is that despite all this attention, this case is about Maggie Murdaugh and Paul Murdaugh, and I'm so thankful that the jurors gave them a voice. You heard about Paul. Obviously, there was the boat case, but you also heard him described as a fun-loving young man, a person who loved life, a person who would do anything for his friends, for anyone. And he's cut down as he was just starting to live his life. You heard about Maggie. You heard how sweet she was. You heard that she was a girl's girl who adapted to the outdoorsman life of her sons, how much she loved her sister and her brother-in-law and their children. And she was cut down in the prime of her life. Both of them, like everyone else, was unaware of who he really was. No one who thought they knew this man, no one who thought they were close to this man knew who he really was. And Your Honor, that's chilling. And I've looked in his eyes, and he liked to stare me down as he would walk by me during this trial. And I could see the real Alex Murdaugh when he looked at me.
So objectionable.
The depravity, the callousness, the selfishness of these crimes are stunning. The lack of remorse and the effortless way in which he lies, including here sitting right over there in this witness stand. Your Honor, a man like that, a man like this man, should never be allowed to be among free law-abiding citizens again. And I would submit to you that the only just sentence here to give justice for Maggie and Paul is the maximum, and that would be 2 consecutive life sentences.
There we go.
Thank you.
What I expect the judge to deliver.
You indicate that no victim would like to speak at this time.
Judge will speak for the victim now.
Would any victim like to speak at any time during these proceedings?
Your Honor, one of the things we did, and we did early on, obviously, as I just said, it's a very complicated situation, but we made the decision early on. We've had our victim advocate here who's been doing a wonderful job, regardless of the viewpoints of any individual family member, to provide aid and service to them, and we made that decision. I'm informed by our victim advocate that none of them wish to speak. The defense can certainly address that, but that's what I'm informed. But they certainly were offered the opportunity as is required, and I want to commend our victim advocate on the excellent job she did in handling this complex situation that we wanted to be sensitive to, because again, none of us are not mindful of the fact of the suffering of this family.
I know Sled Chief Mark Keel is here. Would you like to address the court on any matters, Chief?
No, sir. Just to say, again, very proud of our agents, the work they've done. I'm proud of the partnership that we've had with the Attorney General's office as we've had for many years. And
How's he a
again,
victim?
we're here to see the justice is served, and we believe it has.
Thank you. For the defense.
Your Honor, Mr. Griffin and I would have no comment. The defendant would like to address the court, though.
Mr. Murdaugh.
Good morning, Your Honor. I'm innocent. I would never hurt my wife, Maggie, and I would never hurt my son, Paw.
Thank you, Your Honor.
Thank you.
Anything further?
I don't think further comment is necessary, Your Honor. Thank you.
Mr. Murdaugh, if you'll come before the court for sentencing.
They've got his leg shackled too. That's why he's shuffling like that. I don't know if he's innocent or
This
not.
has been
That's not the question.
perhaps one of the most troubling cases, not just for me as a judge, for the state, for the defense team, but for all of the citizens in this community, all the citizens in this state, and as we have seen based on the media coverage there throughout the nation, you have a wife who's been killed, murdered, a son savagely murdered.
The judge is allowed to rely on the jury verdict. If you believe the jury verdict, life
A
sentence
lawyer,
is the only appropriate sentence.
a person from a respected family who has controlled justice in this community for over a century, a person whose grandfather's portrait hang at the back of the courthouse that I had to have ordered removed in order to ensure that a fair trial was had by both the state and the defense. And I've sat through the trial. Not only have I sat through the trial, but also as the presiding judge of the state grand jury, sat through and participated in the issuance of search warrants of various sorts, bond hearings, and have had to consider many things. And we have this case, and I'm also assigned to preside over 99 others, at least 99 other cases. Though testimony
Like he
has
hasn't
come up
preached.
regarding many of those other cases, I will not make any comment with regard to any other pending matter,
You did.
as
You
I have been
did.
assigned those cases as well. It's also particularly troubling, Mr. Murdaugh, because as a member of the legal community and a well-known member of the legal community, you've practiced law before me, and we've seen each other at various occasions throughout the years. And it was especially heartbreaking for me to see you go in the media from being a grieving father who lost a wife and a son to being the person indicted and convicted of killing them. And you've engaged in such duplicitous conduct here in the courtroom, here on the witness stand, and as established by the testimony throughout the time leading from the time of the indictment and prior to the indictment throughout the trial to this moment in time. Certainly, you have no obligation to say anything other than saying not guilty. And obviously, as appeals are probably expected or absolutely expected, I would not expect a confession of any kind. In fact, as I've presided over murder cases over the past 22 years, I have yet to find a defendant who could go there, who could go back to that moment in time when they decided to pull the trigger or to otherwise murder someone. I have not been able to get anyone, any defendant, even those who have confessed to being guilty, to go back and explain to me what happened at that moment in time when they opted to pull the trigger when they opted to commit the most heinous crime
The judge acts like he
known
found
to
him guilty.
man. In this case, qualifies under our death penalty statute based on the statutory aggravating circumstances
The more this
of
judge talks, the better it is for Alec.
2 or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct.
He did a death penalty case? I doubt it.
Remind me of the expression you gave on the witness stand. Was it tangled?
Tangled web, we weave.
Oh, what tangled web we weave. What did you mean by that?
Meant when I lied, I continue to lie.
And the question is, when will it end? When will it end? And it's ended already for the jury because they've concluded that you continued to lie and lied throughout your testimony. And perhaps with all the throng of people here, they, for the most part, all believe, or 80, 90%, 99% believe that you continue to lie now when your statement of denial to the court. Perhaps you believe that it does not matter, that there's nothing that can mitigate a sentence given the crimes that were committed.
I do need to replace the tie I lost in Vegas, so maybe I will set up a...
A notice of alibi was filed in this case by counsel in November, and we conducted a hearing, pretrial hearing, in which you claimed to have been someplace else at the time the crime was committed. Then, after all of the witnesses placed you at the scene of the crime, at the last minute, or last minutes or days, you switch courses and admitted to being there.
Hey, Nate, I sent you a guest link if you want
And then that necessitated
Twitter.
more lies and
Twitter
continued
DM.
to lie. And I said, where will it end? It's already ended for many who have heard you and concluded that it'll never end. But within your own soul, you have to deal with that. And I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you. I'm sure.
How personal.
All day and every night.
I'm sure. And they will continue to do so. And reflect on the last time they looked you in the eyes, as you looked the jury in the eyes.
Joe, this
I don't know person who's always been such a gregarious, friendly person and cause your life to be tangled in such a weave web such a situation that yours have spun into. And it's so unfortunate
Here you go, Kurt. Twitter DM.
because you had such a lovely family of such friendly people, including you, and to go from that to this. Your license to practice law has been stripped away from you. You turned from lawyer to witness, and now have an opportunity to make your final appeal.
It's not the final appeal.
As an ex-lawyer. And it's really surprising that you're waiving this right at this time. And if you opt to do so, it's on you.
Judge wants in the
You're
bag.
not compelled to say anything. But you have the opportunity to do so.
The judge wants in the bag,
Again,
and then he'll sentence him
I
to life.
respect this court.
Yeah. Yeah.
But I'm innocent. I would never, under any circumstances, hurt my wife, Maggie. And I would never, under any circumstances, hurt my son, Paw.
Well, and it might not have been you. It might have been
What?
the monster you become when you take 15, 20, 30, 40, 50, 60 opioid pills.
60 pills a day. It's going
Maybe
back
you
to
become
Bible.
another person.
Everyone's known him for 20 years.
I've seen that
Addict.
before.
That's how he is.
Yeah, the person standing before me was not the person who committed the crime, though it's the same individual.
He's heard this before. This judge, 22 years doing murder.
You just
trials.
said he was the
We'll leave that at that. Before announcing sentence on these cases,
You're maxing
with
him out.
regard to all of the other pending cases,
What? He's got to plead out of the pending cases. He's confessed
are
to
any of
everything
them
under oath.
here in Colleton, or I'm sure some of them are?
Yes, sir.
Half of them, or
I don't have that in front of me, but there are a substantial number of charges here. There's some.
I just want you to know I'm going to railroad you on those two.
Allendale.
No, Andrew. Leo.
There may be others I'm not thinking of right now.
we might have worn out our welcome here in Colleton.
Colleton's been great.
They have been, and I'll take this opportunity to thank Sheriff Hill and all of the court officials and really everyone I've met and dealt with while here in Colleton County. Just been great. But without any delay, we're going to schedule some of the other matters. I know Mr.
99 other
Harpootlian's
court charges.
scheduling is complicated, and you've sacrificed quite a bit to be able to be here defending Mr. Murdaugh, as well as the Attorney General's office, with all the other many things and obligations you have. And to be able to have the Attorney General here, Alan Wilson, for the period of time that he's devoted to being here, along with everyone else, it's been quite a sacrifice. But there are other victims whose cases deserve to be heard. And this case has jumped some of those other cases. Perhaps jumped it because of this case resulting in an assault on the integrity of the judicial system in our state, law enforcement in our state. Even during this trial, the law enforcement have been maligned for the past
Well, they
5 or
lied to the
6
grand
weeks
jury.
Yeah.
by one who had access to the wheels of justice, to be able to deflect
Damn sure lied to the grand jury.
the investigation And as the evidence is pointed out in this case, the looming storm that Mr. Waters talked about, I can just imagine on that day, June 7th, when a lawyer is confronted and confesses to having stolen over $500,000
Well, he didn't confess on June 7th.
from a
Yeah, he didn't
client.
get this at all. Oh no, he
And
did
he
to
has
the
a
partners.
tiger like Mark Tinsley on his tail, pursuing
A tiger like Mark
discovery.
Kingsley.
in the
On his
case
tail.
involving the death of Mallory Beach. And having a father, for the most part, on his deathbed. I could imagine, I really
But then
can't
go
imagine,
kill your family? That doesn't make any sense, Judge. I'm sorry.
but I know it had to have been quite a bit going through your mind on that day. But amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life.
Well, they were.
Then you saw that on the video.
Not credible, not believable.
But you saw that on the video. You didn't have to believe him.
You can convince yourself about it, but obviously you have the inability to convince anyone else about that.
Yeah, that's true. You can't
So-
convince anybody else about it.
If you made any such arguments as a lawyer, you would lose every case like that. Cases you will never have an opportunity to argue anymore, perhaps your own, as you sit in the Department of Corrections.
So much hate.
Yeah, this guy, he doesn't.
Feel the hate.
Anything further?
Yeah, he hates this guy.
All right, Mr. Murdaugh, I sentence you to the State Department of Corrections on each of the murder indictments in the murder of your wife, Maggie Murdaugh. I sentence you for the term of the rest of your natural life.
What a shocker, right?
For the murder of Paul Murdaugh,
That just shook him to look at him.
whom you probably love so much. I sentence you to prison for murdering him for the rest of your natural life. Those sentences will run consecutive.
Damn.
Under the statute involving possession of a weapon during a violent crime, there is no sentence where a life sentence is imposed on other indictments.
Yeah, there's no sentence on anything else. With 5 years,
That
like
is the
double
sentence
life
of
plus
court,
5.
and you are remanded to the State Department of Corrections.
Consecutive
And officers
life
may
sentences, not even
carry
concurrent.
forth
Consecutive life
on the
sentences.
Hardly
imposition.
matters.
If they kill you and bring you back, you still got to serve an extra life sentence. That's wild. Consecutive life sentences.
Oh, there was a state AG was in the courtroom.
Yeah. But the thing is that he was
Yes,
going
sir.
to 30 years on the other
Yes,
stuff
sir.
anyway. So he know he was going to jail. It's just he's not.
All right, I
coming
think
out.
that's it. I'm going to cut it out before the talking heads get started.
Yeah. Shit.
Um,
I told you.
yeah, and by the
I
way,
told
I
you.
have no idea if Alec Murdaugh is innocent. Whether or not he's innocent is not the legal question. The legal
No,
question
it's
is whether or not the state proved him guilty beyond a reasonable doubt. Alec Murdaugh as a human being doesn't mean anything to me. I don't care if he goes to prison for the rest of his life or not, and he almost certainly will for the financial crimes.
Yeah.
But I care a lot about the process. I care a lot about due process of law, and this was not a just prosecution.
No, not at all. I think the appeal is for a loser. I don't think he's going to win the appeal. I think there's just too much here. But from
And
what
keep
I
in mind, if he
understand,
won an appeal, what would that mean? Just another
means he
murder
goes
trial.
back. We do it again. We do it again. But plus, I think if even if he wins the appeal, he's still doing 30 plus years on the financial. He's got 99 other cases. 99 other
Well, I
cases.
think he's looking at life on the financial stuff alone.
Yeah.
So I don't think there's any reasonable view of the future where he doesn't spend the rest of his life in prison.
Yeah.
That's not my concern though. On the legal merits, Did the state prove him guilty beyond a reasonable doubt of brutally murdering his wife and son?
No,
I don't buy it.
absolutely not. No,
Not an entirely circumstantial case with no credible motive. And their reasonable alternative hypotheses for the killings, all the people who hated him, the boat accident people, the drug people. I don't think anyone should be found guilty on that basis. And by the way, one thing that really bothered me about this, we have these rules of evidence, 403, 404, that are supposed to keep out other prior bad acts, any proclivity evidence, propensity evidence. But I guess all the state ever has to say now is, well, we think that was part of the motive, that he wanted to cover it up. And therefore, anything you've ever done becomes admissible as part of the theory of the state's case. And if that's allowed, if that's the argument that's allowed to get past 403 and 404, why do 403 and 404 even exist?
Yeah. Oh, yeah. So people know 403 or 404, those are the propensity evidence. So, for instance, if you here in this particular case, a lot of, and let's just be honest, if you remove all of the propensity stuff, which is the financial crimes, which is the impersonating police officers, which is all of the thefts and all that stuff that he did, removing that makes this a totally different case, because you can't go, like even now, you can't go and say he lied to his clients, he lied to this, and he's lying to you too, because all of that would be irrelevant to this case. And I think if you do try the case without the propensity stuff, you have a different outcome, because I don't think you can get this. There's no way I can see them getting to guilty without the propensity stuff. But I do have to, I do want to make this argument. So this was the argument that was being made last night, even on Fox News, which I was shocked. Fox News was making this argument.
Wow.
The fact it all comes down, and everybody keeps saying this, it all comes down to the lie about him not being there prior. And what they're saying is that he was texting right after when he went down, he stopped texting. And they're saying that when he stopped texting his friend is when the murders happened. And that puts you from about 8:45 to about 9 o'clock. So they believe that's
is speculation, right? So I've been on the stream for 32 minutes. 32 minutes ago was the last time I activated my phone. Does that mean I died 32 minutes ago?
No, it doesn't. It doesn't. But what they're saying is that he's the only one there. The two guns that were missing happen to be two guns that could be the murder weapons. Like if you put all the circumstantial stuff together, it can lead to a conviction. Now, I don't buy that, because my personal is that I think the state has to prove their case. And I just don't think there was enough here to prove it without the propensity evidence, without them saying he lied about all these other people. I think that emotion got them to where they have the conviction. That's why I said yesterday, when I've been saying it all since we were watching the trial, they're going to convict him, but it's not going to be on the murder. They're convicting him based on the propensity evidence.
Well, it certainly looks that way, right? I mean, I don't even know why we had 6 weeks of trial, because no jury that comes back after 6 weeks of testimony in less than 3 hours with a guilty verdict deliberated. There was no deliberation happening.
No. They knew walking in. They knew walking in this guy was guilty. But the thing is, OJ, they knew walking in he was innocent, right? I mean, he was not guilty, so they came right out. This was a tough case. But I don't know. I know a lot of people were hating on me yesterday because I called it. But you guys got to understand, those jurors were fed shit for 6 weeks. And
longer, for years. I mean, since it happened, ever since SLED falsely claimed they had a blood spattered shirt, that was in the media all over the county.
Yeah, it's in the Netflix documentary. That's the reason why we know he's guilty. And now we know at the end of the trial, they said there was no physical evidence that actually tied him to this scene, unless the only thing that tied him was that he found them. That was it.
Right.
That was the only thing that tied him to the scene. He found him. And all the evidence that presented them, I saw their shot, so I picked up a gun and I got gunpowder on me, but the gunpowder wasn't from shooting anybody, it was from the gun I picked up, right? All these things are equally indicative of somebody innocent as they would be for someone guilty. And I think that's the fear.
And that's a good test for whether or not a claimed fact is a material fact that should be given weight. If the fact could be the opposite and you would still come to the same conclusion, it's not a material fact. And here the state's like, well, he had a bloody shirt. And he also didn't have a bloody shirt. And both of those are consistent with guilt. He had gunshot residue. He didn't have gunshot residue. Both of those are consistent with guilt. He hid the guns successfully at his mother's house, but for some reason didn't also hide the blue raincoat he supposedly had the guns in. That he left out to be found. If that was gone, they'd say he would have hidden that too. Both are consistent with guilt. What the state did here, of course, is start with their conclusion that he was guilty and then just fit all the puzzle pieces into a path that arrived at the conclusion they already arrived at.
But do you think this is his attorney's fault? Do you blame the lawyers for this? I think he had.
The attorneys made mistakes there. I mean, this was not a perfect defense, but I don't think it would have mattered.
But
not when we see the jury come back in less than 3 hours at a verdict.
Yeah, that's true. That's true. Because how do you argue? Is there any mistakes that you could have done differently? Because to be honest with you, me just watching the case, before I watched the Netflix thing, I'm voting not guilty. After watching Netflix, I'm voting guilty. So I'm thinking, yeah, like you guys were saying, it's just the town, everything. Everybody knows this is a bad. Yeah. But it shows you how the stuff from the outside has affected even my thinking about this. But you know, I yesterday there were a lot of people blaming the jury for this, and I think you blame the judge, and I think you blame the prosecutors, because the judge let a lot of stuff in that in no criminal case would be in it. Because
the judge was egregious, just egregious. For example, they had the state on rebuttal brings in this cell phone expert. His expertise is data extraction, and he's allowed to testify as an expert on the physics of the phone. And the defense objects. They said, "No, Your Honor." He says, "Well, you can't object now. You accepted him as an expert in a particular scope." Not an expert on everything. What's he going to talk now about the manufacturing process for cell phones? I mean, he doesn't know anything about any of that. But the judge was just like, told the defense, sit down, shut up. I've ruled. And that's just egregious.
Yeah, that's yes. Because you should be able to object if somebody's testifying outside their expertise. That's bullshit. But again, it's, this judge, I think this judge showed his hand a little bit at the sentencing.
And that was arguably the key piece of evidence in the case was the state's claim that he could have thrown the phone out the window.
Yes.
And absent that expert's rebuttal testimony, he would have had to been in two places half a mile apart at the same time, which would have made it impossible.
Yeah. Well, I think it's I think the problem here is the defense didn't really get to the impossibility of 17 minutes.
No, they didn't.
17 minutes. Because think about this, people. From shooting both of them with two guns, he only has 17 minutes. Clean up, which they said was on with a water hose. Clean up, get the bloody clothes off, hide the guns, and travel to mom's house. 17 minutes.
Yeah, so I mean,
that's a lot.
They did mention it on closing, but they didn't do it effectively. And listen, when I say the defense could have been better, when I'm critical of the defense, I don't mean as human beings. I'm not saying I could have done better, right? They're in the trenches. They're doing this for 6 weeks. Jim Griffin was clearly exhausted on that rebuttal and on that closing. I mean, he was completely wiped out. I just get to sit at my desk and enjoy watching it, right? So I have the luxury of not being exhausted. So when I'm critical of the defense, I mean, in comparison to what a perfect defense might have looked like, but nobody's perfect. The defense isn't perfect. It would be unreasonable to hold them to that expectation. But Griffin on cross of that rebuttal expert and on closing, he was done, man. He was cooked, and those were not good performances.
Kurt, what's going on, bro?
How's it going, everyone?
We're sitting here watching
better
this.
Than Alex Murdaugh.
What you think? Double life.
I was surprised. I was surprised the jury came back so fast. With the 3 hours thing. The typical thinking on this kind of issue is that the jury comes back really quick. It's usually a favorable verdict for the defense, because the idea being, if you're gonna, if it's innocence, it's either innocence because we have to actually go through the evidence to prove guilt in our own mind, or it's a rock solid guilt. Like, something like Darrell Brooks. And even Darrell Brooks, I think their jury took longer than this, if memory serves. But that would be the kind of thing that you'd expect a jury to come back really fast, because it's like,
it's right there. He's on camera. It's over. Yeah.
It's like, what more do you want, right? We're done here. So the fact that the jury came back in this case, which I think is much more ambiguous, whatever you can say about it, while I think there's probably a technical sufficiency for guilt.
Yeah,
I think also that, you know, the jury, there is some combination of the evidence the jury can get to beyond reasonable doubt. I don't think that they should, because reasonable doubt is present, as Andrew has talked about and Nate has talked about and everyone else has talked about. The
I
motive
think if you have to work really hard to get beyond a reasonable doubt,
it's kind of a
it ought
problem.
not be a guilty verdict.
So I was a little disappointed in this jury to come back so fast with the guilt verdict.
Well, the only message I can take, obviously I can't mind read, but the only message I can take, given the brevity of deliberations, is that there were no substantive deliberations. And this was not an overwhelming evidence case. He was not soaked in blood, holding the murder weapons in each hand when the cops rolled up.
Right.
But I think this was cumulative in terms of just everything being there. Like, it turned into, who else could it be if not him? And I know that's an inappropriate question for a jury to be going into deliberations.
Sure, you're shifting the burden to the defense now.
Exactly, but that's what they went in with, right? Who else could it be? Who else saw them alive? Who else was in the place? You have opportunity. You have means, right? The two guns that happen to be missing, and all of those coincidences, which we call circumstantial evidence, just fit just enough to say, if not him, then who? Then you add all the propensity stuff to it. And like I think what Kurt is saying, I think sufficiently a jury could come to this conclusion. Yes. But I think if a jury were to actually take their time and go over the evidence, which I would hope any jury does, and say, could this happen theoretically? Could he do all this in the 17 seconds? Let's walk through it. I think it takes longer than 3 hours. And I think at the end of the day, they probably just went inside there and said, is there anybody here who think he didn't do it? And I think
that's why, especially in politically motivated prosecutions, they're willing to take the shot, because they know there's always a chance the pieces will fall together. And even innocent people get convicted, folks. If innocent people didn't get convicted, we wouldn't need appellate courts. We wouldn't need the Innocent Project. It happens. And a lot of times the prosecutors just hope, like, this is the judge that Binger wished he had in the Rittenhouse prosecution.
Yes. Oh my God.
Yeah, even more so. Sure. Could you imagine
this judge?
I'll
my God, this judge allowed everything. I don't.
Well, whether it's substantially more prejudicial than probative is for the jury to decide, don't you know?
Right. Yeah. It's crazy, because under this standard, this judge's standard, 403 and 404 don't mean anything, because if the state's willing to allege, well, our theory of the case is that those concealing discovery of those prior bad acts was part of the motive for the crime. Apparently, he gets to come in.
That's a 404. It's a 404 exception now. Motive. If you can tie it to motive, it's a 404 exception. So, but I don't see how you get financial crimes as a motive for the murders.
And if there had been an email from Alec Murdaugh to somebody saying, oh my God, I'm about to be blown out of the water by the discovery of this. All right, then you have some evidence. Otherwise, this whole he's going to be discovered, and that's why he killed his wife and son, is complete speculation. There's no evidence to support that. And
the bigger problem, at least for me.
And by the way, he'd been caught before. He'd been caught before in these financial shenanigans, and he'd always gotten out of it. He'd been found with the drugs before, and he'd always gotten out of it.
But see, this is how the analysis should have gone. Okay, you want to bring in this propensity evidence under 404. All right, so you got the financial crimes. Yes, you want it for motive. Now you run it through 403. The balancing test, right? Is it more prejudicial or probative? And I think that's where it fails. And I think that's where the judge made the mistake of law. It fails under that test because it's obviously more prejudicial, right? They're going to convict him on the financial crimes, which has nothing to do with this at this point in time. And it's so tenuous to motive that it's going to be it's definitely going to be prejudicial. And I think that failing is one thing I would be appealing. I would be appealing like, hey, even if you say it's propensity, it failed on 403. This was definitely more prejudicial than probative, especially because it's not only prior bad acts. This is prior crimes, right? He literally has to sit there and say he committed all these crimes on the stand, which I think, and I also going to disagree with both you guys too on this. He shouldn't testify. I think him testifying is what got him caught up here. He shouldn't have testified.
Didn't help. No.
Yeah, I don't think it helped at all. I think one of the reasons why it's different if other people call you a liar than if you go up to the stand and admit that you're a liar. Does that make sense?
Yeah, for sure. I think the biggest problem with the so-called motive evidence is the judge made really no attempt at all to limit or cabin the so-called motive evidence. Because if you somehow believe that his house of cards is coming down that evening because of the $792,000 check or the boat case or stuff like that, if that's somehow your theory of the motive, like the reality is coming crashing in, then okay. But how do you go like back 10 years? Be like, let's talk about all the fraud you did ever. How's that related now to a motive? His motive is 10 years in the making now? Is that what we're saying? So 10 years ago, basically, I started the seeds of my murder plot.
And his problems aren't diminished.
That's what inspired motive by its nature is the thing that inspires you to commit the crime. So for it to be motive, it would have to be the reason that he did it. So 10 years ago, basically, he was starting his very slow moving murder plot. I'm not sure about that one, Judge. So that's the biggest obvious issue for appeal, to my mind, is just the scope. And then you get into 403 issues because you deal with confusion of the issue of jurors, undue delay, undue repetition, undue prejudice, and all that kind of thing. And then, of course, as Andrew noted, the expert testifying about things that he himself says is outside his expertise, but it's okay because he didn't do a scientific test. What? That's sort of the exact problem.
And then that goofy crime scene expert for the state, he's like, well, it was a very, very dynamic scene. Everyone's moving around. Also, he was on his knees to get the gun low enough to fire the shot the way I say it. All right, well, I don't know if you've ever tried to run on your knees. you don't do it very dynamically.
Yeah, this was a shit case. I honestly didn't think they had enough to charge him.
They made stuff up.
Yeah,
they made up the bloody shirt. They made up the other shotguns in the house that supposedly were loaded the same way that the shotgun he was holding was loaded. Those were complete fabrications, and they knew it.
And you got gunshot wounds that are consistent with someone who's under 5'5", right? Who's 5'5" and lower, and he's 6'4". It's like there's just so much reasonable doubt. And the thing I think the defense dropped the ball on so bad is when the prosecutor said about the 2 shooters versus 1 shooter, it's equally likely.
Yeah. There was definitely some moments like that.
That's it. Boom. You should be hammering on.
There were a couple moments like that for the defense, and it would have probably been beneficial to have a demonstrative where you had like each of those things where basically the witness, preferably the state witnesses in particular, said some version of it's reasonable, it could be this, it could be that, and just be like, okay, you want reasonable doubt? Here's reasonable doubt. The state medical examiner said this. They said it's reasonable. It could be 2 people. The state reconstruction expert said this. The state in their own closing said, oh, it's equally probable. That sounds like a reason. And then you go through. So that was a missed opportunity.
I have to believe a big part of it is just how exhausted the defense had to be at this point. And I saw much the same thing in the Derek Chauvin trial, where Derek Chauvin had one defense attorney and an assistant, I guess, another lawyer, but didn't argue anything in court. And then the state had 12, 15 attorneys on the panel, and they were all taking turns arguing. They weren't even all there on every day. And then in the evenings, they were filing motions with the court that the defense counsel had to respond to. So he was in trial all day, then responding to motions all night. And by the end of that trial, you could see that guy was exhausted. And you're just not as sharp when you're tired.
But to give Eric Nelson credit, though, he gave the best defense possible for Derek Chauvin. Derek Chauvin wasn't getting out of there, but he gave a hell of a defense.
I think he did a fine job, but you can see him getting tired at the end.
Oh yeah, definitely. But it's unfortunate. In this case particularly, it's unfortunate because I think this guy, different than Derek Chauvin, had the means. He had multiple attorneys up there. He had a whole law firm right up there next to him. So I don't think that's the same issue here. But what I do think though is that if you add the judge's essentially incompetence with the prosecutor's vigor for just getting it in, there's a lot of stuff that shouldn't have gotten in. And I go on and I'll continue to say he was convicted for other crimes here.
Yeah.
The murder was
just likely.
No, he's going away for.
I mean, it's weird that the judge on sentencing on these convictions spent so much time talking about the upcoming financial crimes that he's also going to preside over.
Yeah.
Yeah.
So I'm not.
And that would scare the shit out of me. If I was him, I'm like, but what's the matter, right? He's going to get more. But I'm going to get 3 more life sentences on top of this.
No.
And the world's just gone crazy over this. They're so emotionally invested. I mean, I'm seeing purported lawyers on Twitter saying that Alec Murdaugh is doing something wrong by pleading not guilty in the financial crimes. I mean, after all, he said he did them, right, in this trial. But folks, you're allowed to plead not guilty and compel the state to prove you guilty beyond a reasonable doubt. That's a fundamental civil right in America. It doesn't make you a bad person any more than wanting a lawyer makes you a bad person.
Yeah.
And you know what they're going to do? They're going to use his testimony in this court under oath as a party opponent.
Sure, and they should.
Of course they are.
There we go. But this guy, even if he gets out on these, and you know this guy's matching them out for the financial crimes. He just literally just heard them all here. You're going into another thing, and also, how can this judge? You didn't ask for this judge to be recused? He has this long history with the guy. He says he's been in parties with the guy. Why are you now his judge? Well, maybe did he have that relationship with all the judges? I don't know. That just seemed weird to me. For you to have such a relationship with the judge and that be the same judge who's now in all your cases. It just doesn't make sense. Aren't they other judges?
It just happens sometimes, I guess. I mean, they're supposed to be more or less randomly assigned. But I remember in the Zimmerman trial, his Deborah Nelson, I believe, was his judge, and she was terribly biased in favor of the state. He got acquitted, and then he turned around and he sued NBC and other news agencies for fabricating photos of him to make him look more guilty. Yeah. And she turned out to be the civil trial in a civil case against the media, and she dismissed the civil claim against the media. And then someone tried to kill George Zimmerman. He was driving down the road to a doctor's appointment, and someone tried to shoot him in the head. That guy got charged with attempted murder. And guess who the criminal judge was in that trial, in which now Zimmerman was the victim of an attempted murder charge? It was the same judge, Deborah Nelson. The world's a weird place.
Well, listen, guys, it's sad because I still remember the great, like when Rittenhouse got off, which shows you how crazy this world is, right? Rittenhouse, when he got off, we celebrated, but there shouldn't have been celebration. He should never even been charged, Rittenhouse. But we celebrate that. Then you got Kim Potter, which was, I think, a total travesty of justice. That one is just even as egregious. And now you have this, where I think, like I agree with Kirk. Technically, based on the law, I don't think you can get this overturned by saying insufficient evidence, because you had enough where the jury could say, we didn't believe him. So this is where we're going with this. And I think that's where they're going to hang their hat on. That's why I agree
that's the problem. The 6 weeks of testimony, the way the judge kept expanding the scope of the testimony, I think that's, if it wasn't a strategy on the part of the state, it should have been to overcome any future claim of insufficient weight of the evidence, because you look how much we had, right? Mm-hmm. We had dozens of witnesses. Now, to my mind, if you have 1,000 pieces of evidence that are immaterial, it shouldn't make any difference. It's just layers of tissue paper. It doesn't get you up to proof beyond a reasonable doubt. But it's a matter of fact within the province of the jury, exactly the kind of thing. Appellate courts don't like to reverse convictions. What does Steve Gosney say? Less than 1% of appeals end up in a reversal. So often, if you read those appellate decisions, often it seems like they're just looking for a reason not to reverse. And province of the jury is one of their favorite ones.
The judge of the facts, huh? The judge of the facts. But the thing is that I also got to say, one thing about the evidence here is that putting him on the stand and putting his credibility before the jury, I think when you go back to that jury room, it's either do you believe the state or do you believe him, versus do you believe the state or do you believe the other witnesses that you've put on. And I think when they made this credibility test between the state's witnesses who had lied and him, who is a confessed liar, who says I lied during this trial, he's lying everywhere, I think you lose that. And I think that's the problem here. By him going on, that dichotomy of do you believe him or do you believe the state, that was the thing that just destroyed it. And not having a good answer for that, why did you lie before? And I understand, like you guys were saying before, Sled, he don't trust Sled. That's just not a good enough answer when your family's just been killed. You got to give me something better than he didn't trust Sled. You didn't trust Sled when your family's just killed and you're right there. They say, when's the last time you saw him? Let's try to find the killer. You lie. I think that hurt him a lot. But I think that alone doesn't convict him. I think that plus the propensity evidence gets you to where we're at now, with 2 consecutive life sentences.
Yeah, it could be, gentlemen. Anyway, listen, I've got a media thing I have to do, but I wanted to cover the sentencing. I really appreciate you guys coming on, but I won't keep you any longer. Wait, before you go, I'm always bad about this. Where can people find you? Nate,
My name is
what-
my name is Nate the Lawyer. Just Google Nate the Lawyer, and you'll find me there. I'm currently in a lawsuit against Christopher Boozy. I'm doing a
Boozy
whole bunch of
Bucks.
stuff. So that's right, Boozy Bucks. So hopefully we'll be getting a decision there soon. And hey, listen, guys, if you follow me, two things. I love the law, but I just give it to you the way it is. You're gonna agree with some of the shit I say, you're gonna disagree with some of the shit I say, but I don't care anything about Murdaugh, but I do care about the law. That's why I'm able to say I would have voted not guilty, but I understand why he's convicted.
And you can find me on Uncivil Law. We got some great U.S. Supreme Court case videos coming out in the near future. 3 decisions recently from the U.S. Supreme Court I've filmed videos on and edited, so just need to be posted. Plus, we got oral arguments we're going to be doing in the Twitter case at some point in the near future, plus also the student loan case that was just argued at the U.S. Supreme Court. I believe that was yesterday. We'll be doing the oral argument discussion of that, trying to figure out whether or not the Biden administration can waive student loan debt based on the relative loss. So should be fun. Check me out on Civil Law.
All right, guys. Thanks so much. Thanks for coming on.
Take
Talk
care,
to you
guys.
soon. All right, folks, and I'm going to wrap up. But before I do want to mention, of course, today's content has been sponsored by none other than me, Law of Self-Defense. Saturday, April 15th, we have upcoming our Law of Self-Defense Advanced Live Online class, full-day class on how to make yourself hard to convict if you're ever compelled to use force in defense of yourself, your family, your property, an unattractive target for prosecution. This is the only class scheduled for 2023, so don't miss it, Saturday, April 15th. And if you can't make the live class on Saturday, register anyway. You'll get access to the replay of the class for a month or so afterwards, so you can watch it at your convenience. And if you watched it live, you can rewatch it. If you'd like to refresh your recollection on parts of the class, it's all day live, taught by me, streamed to you at your computer, plenty of opportunity for Q&A. And if you sign up this month, March, for that April 15th class, you get 10% off your registration. Learn more and sign up at lawofselfdefense.com/advanced. You might also consider getting a copy of our very popular book, Law of Self-Defense Principles. Check it out on Amazon, 1,200 plus reviews, 5-star rated bestseller in their criminal law segment, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We give you the book for free. We only ask that you cover the cost of shipping the book to you. You can get the Law of Self-Defense Principles at lawofselfdefense.com/free book. Makes sense? Or you can get the beautiful, handsome hardcover edition of the same book, Law of Self-Defense Principles. And you know where to get this, folks, don't you? The hardcover of Law of Self-Defense Principles. You can get it at lawofselfdefense.com/gethard. All right, folks. Oh, Super Chats. I should check out Super Chats. And also the member comments. Let's see. Law of Self-Defense members, if you'd like me to answer a question, folks, during the remainder of this live show, make it a Super Chat. $5 minimum on YouTube. Do the same on Rumble. I'll check out the Rumble rants if anybody does Rumble rants. Or be a Law of Self-Defense member. Put your question in the member chat on the dashboard where we're also streaming and get your question answered for free. No additional cost. And being a Law of Self-Defense member, folks, it's about 30 cents a day. Less than $10 a month. And you get all your questions answered instead of paying $5 plus a pop. So let me check out. Oh, you can become a Law of Self-Defense member at lawofselfdefense.com/join. You can do that right now. lawofselfdefense.com/join. Let's see. Yeah, Alec was, the jury returned their verdict of guilty on both the murder counts and, of course, the gun charges yesterday after less than 3 hours of deliberation. Last evening. Steven says, Andrew, I'm a grad student and I've officially decided to go to law school after watching you, Nick, and everyone else taking the LSAT in June. Good luck, Steven. Good luck. I hope you're doing it because you have a passion for the law and not for the money. There's a lot of not very wealthy lawyers out there, I'll tell you that. For the LSAT, the best advice I could give you is take lots of practice exams. That's what worked for me. Joe writes, ABC interviewed a juror this morning. They said all the jurors had a guilty verdict in 45 minutes. Yep, no deliberation there. Joe Dobbs says, if he wins an appeal, is his testimony in this trial admissible? Yes. Paul If he does win an appeal, I think he'll get the same judge. So it's a hopeless case. So normally that's true. Normally, if you're convicted and you appeal and you get a reversal of your conviction and it's remanded for a new trial, normally it goes back to the original trial judge. I've heard that this judge is retiring. If that's the case, and appeals typically take years. So if he's retired by the time the conviction is reversed and remanded for a new trial, obviously there'd be a new judge. And that new judge, it's a whole new trial. So that judge is not bound by the rulings of this judge. Yeah, you don't want to be a criminal defendant, folks, if you could possibly avoid it, because you always hear me say there's at least a 10% chance you get convicted, even if you're completely innocent, for a variety of reasons. And we saw a lot of those reasons in this trial. Let's see. Yeah, so if there were a new trial with a different judge, the different judge could make different rulings on all these prior bad acts evidence. Let's see. Michael Becker, do I think he will appeal? Well, yeah, why not? I mean, what else is he going to do? So let's presume he's going to be sentenced to life in prison for the financial stuff. So he's spending the rest of his life in prison. He is a trained lawyer. He can represent himself. I would appeal, even though it's not going to change whether or not I'm prison. It would change whether or not I'm have been found guilty of murdering my wife and son, and obviously that's important to him. So what else is he going to do with his day but appeal? Even if he's doing it pro se, even if he's representing himself. And that wouldn't really cost him any money. Let's see. Question, worst decision because it was emotion-based, Chauvin or this? You know, it's hard to say. I mean, obviously here we don't have that racial component, but juries are supposed to render verdicts based on reason. That's why we have phrases like reasonable doubt, not on emotion, favor, disfavor, bias, and they're told that. But they'll do it anyway, especially if doing it is made easy by the courts. Okay, let me take a look at Super Chats. That was all the membership stuff. Supers. What have we got? Oh my gosh, we got a whole bunch. Wow. Okay. Smoky Bones, $20 super chat. Thank you very much. Says, I never get to see you live, but I'm off work today. Happy to be able to send you a super chat. Yeah, with all these super chats, I may be able to afford a new tie. Hey, and speaking of which, $50. Holy cow. From Amazing Wireless 2, $50 for the Branca Tie Fund. Thank you. For those who don't know, I was recently in Vegas with Nick Ricardo Law for a little get-together he'd arranged. And I went there with a tie, and I left without the tie. And it was one of my better ties. So yeah, I have to replace it. Kimmy, $10 tie donation. Thanks so much. Thanks for picking up the slack of those other shyster lawyers who ditched us today. Healthy Mama, $5 super chat. Who is the black lady behind Alec? That's not agreeing with the judge. I didn't see it. I'm sorry. Mandy Karavicius, $5 super chat. If this was Wisconsin, Alex would face a $500 fine. Enraged Bacon, $20 super chat. It sounded like they just really wanted to give the death penalty out. So what are the chances for appeal, even though appeals are for losers? Well, there's lots of grounds for appeal. And frankly, it's so just watching the trial as it progressed, there were many opportunities for objection that the defense did not take. And typically, if you don't object to something you believe is error, it's not preserved for appeal. The appellate court doesn't want to hear it. It's a little more complicated in this case because I know the defense objected to a lot of stuff early on, even before the trial proper started, and they kept repeating, we don't have any additional objections. But all the objections we made earlier, we're still holding on to those. That's a sketchy strategy for the defense because a lot of times the appellate courts are looking for reasons not to reverse. And they can get very particular about whether or not an error has been preserved for appeal. And if you have what's called a running objection, which is kind of what they did here, a lot of times the appellate courts will say, no, unless you objected each and every time something wrong was done, we're going to consider it waived. So it can be risky on the part of the defense. There were lots of grounds for appeal in this case, but appeals are for losers, right? You're only appealing if you lost the trial, and the chances of winning a meaningful appeal, a result on appeal, are minuscule, less than 1%. And if you do win, you get a reversal of your conviction, remand for a new trial. So you're doing the trial over again. You're not getting the charges dismissed with prejudice so that you're clear of the charges. 1 in a million, 1 in 10 million, it just doesn't really happen. So lots of grounds for appeal. You know, again, if I were Alec Murdaugh, got nothing else to do with my time in prison, so I may as well do that. Vince Loker, $5. Thank you so much. Says 100% agree with Nate. The judge looked for a reason to bring in all the other stuff. Defense opened the door according to the judge, and that was it. You know, I have to wonder with the defense if they just didn't know it was all coming in anyway. If they didn't know from the beginning. Certainly, the judge would telegraph. He'd say, I'm not going to make a ruling now. But he would telegraph what his ruling was going to be. For example, when the question of the state rebuttal came up, and the defense said, well, if they get a rebuttal, we should get a surrebuttal. And the judge was like, well, I'm not ruling on that now. But I want you to know I'm really disinclined to allow a surrebuttal. Well, you can't get a clearer message from a judge than that. He's not going to do it. Jim Altig, $10. Tank of gas for the bike. Thank you for all you do, sir. Yeah, my bike has a big gas tank, Jim. I think it's 8 gallons, 7.9 gallons. So $4 a gallon, $28, $32. Let's call it $30. So it's a third of a tank of gas, but it's much appreciated. Snowboard Dan, $20 super chat. Do you think they convicted him just so they had him for life instead of maybe Alex slip by and other fraud issues somehow? I mean, is there any way he gets out from under the financial fraud issues? Maybe. If he had something to trade, I mean, that happens all the time. So he stole a lot of money from people. But most of the people he stole money from were made whole. The law firm paid. So ultimately, the clients were made whole, is my understanding. Of course, the law firm's out a ton of money, but they're not poor. If he had, drug information on a drug network that he could sell to prosecutors, might they make a deal on the financial stuff? Sure. Happens all the time. So they definitely wanted both for sure. And of course, it was good theater for the prosecution. Charles Argo, $35 of 35 something ZAR. I don't know what ZAR is. But 35 something, thank you very much. Please show the CBS interview with a juror. It supports your reasoning. So, folks, I never believe what jurors say after a trial. I just don't believe it. There's so many forces on them to fabricate some narrative, to reduce apparent social pressure on them, family pressure on them. They come to their verdict. That was their verdict. And jurors who've been released or jurors after they've done their verdict, I hear them all the time say things like, oh, if only I'd known that additional information, I never would have voted for acquittal. Is that true or not? Are they only saying it because now that they've voted for acquittal? Say like in the George Zimmerman case, this happened with a number of jurors. Well, they're back in their community, and nobody can believe they just released what the public believes is a terrible, horrible, racist murderer of 12-year-old Trayvon Martin. How could you acquit that monster? So they have to come up with some narrative to relieve the social pressure from themselves. So I never really believe what jurors say after the fact. Let's see. Crafty, $10 super chat. Thank you so much. Really appreciate your coverage of this very long trial, Branca. Thank you very much. That's very kind. Jamie Green, $5 super chat. Thank you. I watched the documentary during VWatch, and it made me see many others who had motive and gave me reasonable doubt. I don't know what VWatch is, but I can tell you folks that I didn't watch any of the documentaries, any of the true crime podcast stuff. When I'm covering a trial, I try to work. I mean, I'm aware those things exist, of course, but when I'm covering a trial, I'm trying to limit my legal analysis and commentary to evidence that's actually admissible in the trial. So I try to filter all that other stuff out. And when, for all we know, that other stuff is gossip, rumor, innuendo, has no basis in fact at all. And that could go both ways. So I try to limit myself to the actual evidence admitted in trial. Rocky, $5 super chat, writes, Alec was guilty by the jury the second he walked in. Jurors don't need more than 5 minutes of trial and probably tainted by media and peer pressure. That seems likely, and that's one of the risks. That's how innocent people get convicted. You have 2 years of propagandizing by the state, fabricating claims of evidence like bloody shirts, and then you have 6 weeks of trial. You have a couple days to pick a jury. So are you picking a jury? They all say, because you ask them, can you be fair? Can you be impartial? Can you be unbiased? Can you set aside any preconceptions? And of course, they're only seated on the jury because they say, yeah, I can do that. Can they really do it? Do they mean it? We don't have mind reading machines. Kingslayer Damocles, $10 super chat. Thank you so much. Writes, he kept saying, meaning the judge, he kept saying the defense suggested or committed like an assault on Sled. But literally the day before closing, Sled got fined millions for lying to the court and discovered problems in a different case. What a joke of a judge. Yeah, I don't think much of this judge. I don't know about the Sled fine thing. I'm willing to believe it's true. I just don't know anything about it. I do know they lied here. They lied to the grand jury about the bloody shirt. They lied to the grand jury about similar weapons being used to the murder weapon being found in the house. And they knew those things were lies. They knew they were lies. So let's see. Holly Mania. And by the way, folks, as far as I'm concerned, if the authorities lie to a grand jury to get an indictment and that's discovered at trial, all the charges should be dismissed with prejudice. That's the only way to prevent law enforcement from railroading people who ought not be put to the risk and cost of trial, being put there unfairly by the police lying. Just like if the police lie on a warrant, the evidence gets excluded. Well, I think we should apply the same principle here. And does that mean that some guilty people will end up going free? Sure. But if there's any other way to keep law enforcement as honest as possible in getting an indictment on someone, I don't know what it is. Holly Mania, $10. Thank you so much. Thanks for the coverage. Gary, $20. Thank you so much. Is self-defense a human right? Well, it's a natural right, and humans are part of nature. Animals defend themselves, right? So it's about as profound a natural right as life could have. All right, let me take a quick look back at the members. Let's see. David, Law Self-Defense member David says, Nate is wrong. Even if all that stuff, the other stuff, the prior crimes was kept out, I think the jury would have convicted him. The press had already found him guilty and poisoned the jury. Seems likely. Let's see. I may have covered all this already. Yeah, I did. And let me see if I can figure out how to do Rumble rants. I don't really know how to do Rumble rants. Well, now it's asking me to pay for a Rumble rant myself. I think I'll pass on that opportunity. Let me scroll through and see if they're highlighted in some way. That would be useful to me. And it looks like they are not. So I have to say I was really troubled by all the judges' commentary during sentencing. It came across to me as very, very personal, very biased, really bizarre. But having said that, my legal practice, the cases I consult on, we almost always get the charges dismissed, or at least the person put into a diversion program. We don't get a lot of convictions. So, even when we get a conviction, my job is over by then. So I'm not really part of the sentencing discussion after the fact. So I can't claim great legal expertise on sentencing or what's common among judges but this certainly struck me as extremely personal commentary. I'd like to hear from a guy more experienced in sentencing, like and appeals, of course, like Steve Gosney, on the judge's demeanor here. All right, so I should also mention that in just about an hour, I'm supposed to be on the Megyn Kelly show. This is the Megyn Kelly from Fox, but of course she's not on Fox anymore. She has her own show on the internet now. Let's see. Let's see. But so 12 p.m. Eastern time, which is when? In about 3 hours, I guess. 9, 3. Well, anyway, 12 p.m. Eastern time is when they told me. I don't know if it's going to be live, though. So I would just Google Megyn Kelly show and see when they're scheduled to broadcast. I'm not sure if it'll be a live show. They want me to talk about this trial. They say they want to ask me about other stuff. The latest on Alec Baldwin. Jesse Smollett asking for a retrial. I guess I don't have much to say about that. I hadn't even heard about that. And the Arizona rancher accused of killing a Mexican migrant on his property. So presumably we'll get to some or all of those topics on my appearance at the Megyn Kelly show. If it's not live, presumably it'll be streamed sometime later today. Yeah. All right. That's it, folks. I'm going to remind all of you, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, hopefully tomorrow, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.